You're listening to the Valley Current.
It's stamped with an official gold seal from the United States government.
Right. A literal patent deed.
Yeah, exactly.
Yeah.
And the government is telling you this piece of paper is a highly valuable asset. I mean, maybe it's worth tens of millions of dollars.
Easily in the tech space.
Right. So you build a whole company around it. You hire a team. You raise capital, all based on the authority of this one exact piece of paper.
Because you think you own the technology.
Exactly. But then down the street, sitting in a federal courthouse, a totally different branch of that exact same government is like actively waiting to tell you that your piece of paper is entirely worthless.
Yeah, they're just waiting to shred it the second you walk through the door.
It's insane. Welcome to the completely bizarre, two-faced reality of technology ownership today. We are taking a massive deep dive into some really revealing source material.
It's a fascinating document.
It really is. It's a newsletter published on May 30th, 2026 by the computer law group LLP and authored by their managing partner, Jack Russo.
And the origin story of this specific newsletter is great because it actually stems from a reader calling them out.
Right, yeah. A reader basically emailed them and said, hey, you guys are only looking at half the board here.
Which is such a fair pushback. Because previously, the firm had published this analysis arguing that federal courts are doing this massive expansion of the public domain.
Meaning what, exactly, for the listener?
Meaning federal judges are aggressively making it harder to lock up software, machine learning, and AI with patents. They are actively pushing these concepts back into the commons.
So keeping them free for anyone to use.
Exactly, just out in the open.
So if the courts are shutting down patents left and right, this reader asks the million-dollar question, what about the US PTO?
Right, the actual federal agency whose sole job is handing out these patents. What are they doing?
Yeah, and Russo's answer in this May 30th newsletter outlines this concept he calls the two-track public domain.
It's just this massive institutional tug of war.
Literally moving in completely opposite directions at breakneck speed. And, this friction isn't just some academic debate for law professors.
No, absolutely not. If you're building something today, this is your operational reality.
That is the core mission of our deep dive today. Because if you are an AI founder trying to figure out how to protect the startup you just poured your life savings into, or
a software developer terrified of getting sued.
Yeah, exactly. Or just someone trying to understand who actually gets to own the digital future. This invisible bureaucratic tug of war is dictating the rules of the game for you.
It dictates everything.
So let's unpack how this two-track system actually functions on a mechanical level.
Yeah, to understand the mechanics, there's this brilliant analogy in the newsletter that frames the chaos perfectly.
The stadium one.
Yeah, the stadium. So visualize the entire American patent system as this massive sports stadium. But it has two completely separate scoreboards operating at the exact same time.
For the exact same game.
Exactly. One scoreboard is operated exclusively by the US PTO. And right now, under their current leadership, that scoreboard is just lighting up.
They're putting up massive points for inventors.
Right. They are issuing patents, welcoming software apps, basically rolling out the red carpet for AI builders.
But the second scoreboard
is operated by the federal courts.
Yeah.
And those judges are actively subtracting points.
Yeah, whenever one of those new AI patents gets challenged in a real-world lawsuit, the courts just strike them down with incredible prejudice.
Both scoreboards are real, but they display totally different scores.
Which is wild. So I want to stop and figure out how we even got here, because historically, the patent system wasn't always this schizophrenic.
No, definitely not. For decades, practitioners viewed it as a pretty coherent system.
The agency and the court spoke the same language.
Yeah, if the PTO issued a patent, there was a really strong presumption in the courts that it was valid. They were calibrated.
So what broke it?
The massive earthquake that cracked the stadium in half was in 2014. It was this Supreme Court case called Alice Corp v. CLS Bank International.
Oh, man. Alice. Anyone working in software for the last decade just felt a cold chill hearing that name.
It's the absolute boogeyman of software patents.
For good reason. Let's briefly break down what the Supreme Court actually did there.
Well, the case involved a computer system acting as a third-party escrow, basically holding money in the middle of a financial transaction to mitigate risk.
So neither party gets scammed.
Right. And the Supreme Court looked at this and said, wait, Intermediated settlement is just a fundamental economic practice.
Like, humans have done this with pen and paper for centuries.
Exactly. It's an abstract idea.
Yeah.
You can't just take an abstract idea, say, do it on a generic computer, and call it a patentable invention.
You can't just slap a microchip on a banking concept.
Yeah, you didn't invent a new machine. That became the governing logic. And after Alice, the whole system shifted toward a much narrower view of eligibility.
It got way harder to patent software.
Significantly harder. And crucially, under previous US PTO directors, like Andre Iancu and Kathy Vidal, the Patent Office actually moved together with the courts.
They tightened their belts to match.
Right. But today, as the newsletter shows, that historical alignment is entirely shattered.
The Federal Circuit Court of Appeals is still using that Alice precedent to just slaughter patents.
Yeah, and for context, the Federal Circuit is the specialized federal court for all patent appeals. They're the supreme authority right below the actual Supreme Court.
Right, and they are striking things down under Section 101, which is the abstract idea exception rule.
While the PTO has basically decided to stop carrying and issue them anyway.
To see how strict the Federal Circuit has gotten, we need to look at this anchor case from April 2025. Recentive Analytics, Inc. v. Fox Corp.
Yeah, Recentive is the perfect illustration of how harsh the courts are right now.
Let's break down the facts. What was the technology they were looking at?
So, the panel, which was Judges Dyke, Prost, and District Judge Goldberg, they were looking at a patent claiming the use of machine learning to predict sports broadcasting metrics for Fox Corp.
Okay, so analyzing data environments.
Right. And the court drew a very hard line. They ruled that simply applying generic, off-the-shelf machine learning to a new set of data is completely patent ineligible.
Wait, hold on. Let me translate this. If you build an AI tool that analyzes, say, agricultural weather to predict crop yields,
Okay.
but you're just taking a standard neural network and feeding it farming data, the court says you didn't invent anything.
That is exactly the mechanism they are attacking. The court's logic is that data analysis, even complex pattern recognition, is fundamentally math.
It's an abstract idea.
Right. Simply using a known tool to do math on new data isn't a technological invention.
Wow.
They explicitly stated that unless your patent discloses genuine, concrete, structural improvements to the machine learning models themselves.
Meaning you changed how the neural network fundamentally operates.
Yes, at a base level. Unless you do that, you get zero patent protection.
That is an incredibly high bar. You have to prove you built a better engine, not just that you drove the car somewhere new.
That's a perfect way to put it. And this isn't just some passing opinion. The Supreme Court officially denied certiorari on December 8, 2025.
Meaning they formally refused to take the appeal.
Exactly, which cemented the Recentive decision as the ironclad law of the land for all federal district courts.
And the sources show they're applying this ruthless logic beyond just heavy machine learning, too.
Oh yeah, they are targeting the entire software ecosystem. The newsletter highlights this September 2025 case, Rideshare Displays, Inc. v. Lyft, Inc.
Right, what was that one about?
The court was evaluating patents for user experience improvements. Specifically, using a system to verify a passenger is getting into the correct Lyft vehicle.
Okay, so UX stuff.
Right. And the Federal Circuit ruled that improving a human interaction process is not a technological improvement to the computer itself.
It's just the abstract idea of verification on a screen. It really seems like any software that just makes a human's life easier without physically upgrading the hardware is getting hammered.
It is. And then there was In re McFadden in early 2026. That one dealt with the actual vocabulary people use to try and trick the courts.
Right, the nonce terms. Explain what a nonce term is for the listener.
Think of it as a generic, technical-sounding placeholder word, like module or subsystem or logic unit.
Just dressing it up.
Exactly. Patent drafters used to use these to make an abstract idea sound like a physical machine. Instead of a rule for sorting data, they'd write a data aggregation module.
And the McFadden court said no more.
Right. They affirmed the rejection, basically saying, we see right through this trick. Vague nouns don't magically create an inventive concept.
So federal judges are scrutinizing the math, rejecting the vocabulary tricks, standing at the gates.
Fully blocking abstract ideas.
But this brings us to the most jarring piece of the newsletter. The Federal Circuit actually fired a warning shot directly at the USPTO in ENCO Kyoma Systems v. Davincia.
Yeah, ENCO Systems is the absolute crux of this tension. The Federal Circuit explicitly stated on the record that they are not bound by the internal rules of the PTO.
The internal tribunal of the Patent Office, let me use an analogy here because the magnitude of this disconnect is insane.
Go for it.
It sounds like getting a driver's license from the DMV. You pass their specific test, they hand you the card, you feel great.
You're a licensed driver.
Right. But then you pull onto the interstate, the highway patrol pulls you over, looks at your license, and pulls out a totally different rule book.
The DMV standards are too low.
Exactly. This license isn't valid on our roads. Why on earth would the DMV actively change their rules to hand out more licenses if they know the highway patrol is going to tear them up?
It completely defies traditional logic. To answer why the US PTO changed its rules, we really have to look at the massive administrative pivot that happened in late 2025.
The new management.
Yes, the new boss is Director John A. Squires.
This transition feels like a corporate takeover. Who is this guy driving this massive shift?
Well, his rise to power was very abrupt. Kathy Vidal left in December 2024. Then, in March 2025, President Trump formally nominated Squires.
And his confirmation wasn't just a rubber stamp, right?
Far from it. It was a battle. He was confirmed in September with a very tight vote of 51-47.
Highly contested.
Yeah, and sworn in on September 23rd by Judge Ryan T. Holt as the 60th director. But what's fascinating is his resume. She isn't a standard career bureaucrat.
No, he brings a very finance-heavy profile.
Right. He chaired the emerging companies practice at Dilworth-Paxson, but the defining era of his career was 2000 to 2009.
When he was the chief intellectual property counsel at Goldman Sachs.
Exactly, Goldman Sachs.
Which explains so much about his worldview. He's rooted in financial tech, risk management, and the commercial value of ideas as assets.
While at Goldman, he focused heavily on AI, blockchain, and fintech. He views patents as foundational collateral for securing venture capital.
And then there's the most shocking detail for patent purists.
Director Squires is not a registered patent attorney.
Wait, I need to pause on that. The head of the U.S. Patent Office cannot legally file a patent on behalf of a client.
That is correct. He lacks the specific registration to practice before his own agency.
That is wild.
But that outsider perspective drives his mandate. During his confirmation, he promised to reduce uncertainty under Section 101.
He viewed the strict rejection of AI patents as a threat to American economic dominance.
Right. He treats the Patent Office like a macroeconomic engine, not a legal checkpoint. On his first day, he personally signed 2 new patents in highly challenged fields.
Blockchain and medical diagnostics?
Yep, and literally announced the doors to America's innovation agency are wide open.
Okay, philosophy is clear. But how does an outsider force thousands of career examiners to change their daily behavior?
He executed a highly coordinated 3-step pivot. Step 1 was on August 4, 2025. The Kim Memo.
Let's break down the Kim Memo. Who is Kim and what did it do?
Deputy Commissioner Charles Kim drafted a memo directed at specific technology centers 2100, 2600, and 3600.
The departments that handle computer architecture, communications, and e-commerce. The software examiners.
Exactly. The memo told them to stop overextending the mental process exception.
Oh, like when examiners would say, a human could do this math in their head, so it's not patentable.
Right. It ordered them to stop doing that unless a human could practically do it without a computer. But more importantly, it established a radically new standard of evidence.
This is the part that changes everything.
It decreed that examiners could only reject claims under Section 101 if the ineligibility was more likely than not.
So mechanically, a greater than 50% threshold.
Yes.
If an examiner is staring at complex machine learning code, and they are 50-50 on whether it crosses the line.
The close call now structurally favors the applicant. The tie goes to the runner.
Wow. And for a busy examiner with a strict quota, if the burden of proof to reject is that high, it's just faster to allow the patent to issue.
Absolutely. But a lowered barrier isn't enough without a blueprint. Which brings us to step 2.
Providing a legal cover.
Right. On September 26, 2025, a PTO panel issued Ex parte Desjardins. This involved a complex machine learning claim by DeepMind and Google.
And Squires personally participated in this panel. What was the technology?
DeepMind claimed a specific reinforcement learning method. The examiner rejected it as abstract math, but the Squires panel reversed that.
On what grounds?
They ruled that because DeepMind detailed how the training loop itself physically improved memory usage and processing efficiency, it was a genuine technical improvement.
It passed the test.
Yes. And on November 4th, Squires designated this decision as precedential.
Meaning every single examiner in the building is now legally required to follow it.
Exactly. He essentially printed a new page for the rulebook. If you model your application after DeepMind, the examiner must approve it.
Okay, step 1. Lower the barrier. Step 2, give a mandatory example to approve. What was step 3?
Formalizing an escape hatch. The SMED memos in December 2025.
Subject matter eligibility declarations. How do those work mechanically?
It formalized a channel under Rule 132. If an examiner is on the fence, the applicant can submit a sworn, signed declaration from an expert.
Stating, I swear this provides a concrete technical improvement.
Right. The memos encourage examiners to accept these sworn statements on close calls to clear the backlog.
They rebuilt the entire machinery in months, and the data shifted immediately, didn't it?
Staggeringly so. Look at the PTB's Section 101 reversal rate. Historically, if you appealed an examiner's rejection, you won maybe 8 to 12% of the time.
The House always won.
Exactly. But by November 2025, that reversal rate spiked to 29%. Tripled almost overnight.
That is insane.
And in cases like ex parte carmody, the judges explicitly wrote they were reversing rejections because they were adhering to Squire's new guidance.
But wait, if the PTO is letting all these fragile AI patents flood in, what happens when a terrible patent slips through?
Yeah, that takes us into the post-grant phase. And this is where Squires is facing intense criticism. The total shutdown of the PTB.
Right. We need to explain the PTB's origin story to understand why critics are so angry. Why does it even exist?
Back in the early 2010s, the tech industry was getting ravaged by patent trolls.
Shell companies buying up vague 90s software patents and suing startups.
Right. And because federal court discovery costs millions, trolls would just offer to settle for, like, $100,000. It was pure economic extortion.
Cheaper to pay the ransom than prove the patent invalid in court. So Congress intervened.
In 2011, they passed the America Invents Act, creating the PTB. The idea was, if the patent office makes a mistake, the public shouldn't have to spend millions in court to fix it.
You could challenge it administratively right back inside the patent office for a fraction of the cost.
Exactly, an inter partes review, or IPR. For a decade, if a tech company filed an IPR showing a patent was likely invalid, the PTA instituted a trial about 67 or 68% of the time. 2/3
of the time, they'd say, yeah, this looks suspect, let's review it.
But under Squires, that 68% institution rate has fallen off a cliff into near zero territory. During the interim era, in mid-2025, they leaned on a doctrine called settled expectations.
What does that mean practically?
Basically, if a patent is issued and the owner built a business on it, the market has a settled expectation. It's valid. So the PT should refuse to review it to avoid disrupting the economy.
Even if there's evidence it's invalid.
Yep. Using that logic, discretionary denials spiked to 61%.
And then Squires gets confirmed in October and takes the wheel himself.
He literally centralized the power. On October 17th, he issued an open letter removing authority from the PT judges and consolidating IPR decisions into his own hands.
One man controlling the gate.
And the gate slammed shut. In his first weeks, he reviewed 34 petitions begging for review. He denied all 34.
A 0% institution rate.
By December, it barely nudged up to 4%. The chilling effect was instantaneous. In November, only 66 IPRs were filed, way below the historic average.
Because why spend the money if the director's just going to unilaterally deny it?
Right.
How does he justify turning off a quality control system that Congress created by law?
He frames it around factory logic. During his hearings, he said, IPRs have a 68% defect rate. If we were a factory, 68% of our products being found defective is unacceptable.
Hold on, let me process that. If a car factory realizes 68% of its engines explode, the solution is to fix the robots building the engines.
Right.
Squires is basically firing the quality control inspectors, catching the bad cars, and then declaring the factory a 100% success.
That is exactly how critics see it. Now, to be fair, Squires argues the solution is front-end quality. Better AI search tools for examiners, pilot programs like ASAP to give them more time.
He wants quiet title for founders.
Yeah, his deputy director argued founders need to know their patent won't get revoked 5 years later.
Sounds great for the patent holder. But the newsletter points out this is a nightmare for a founder actually trying to build software today.
Because the cheapest defense mechanism against trolls has been locked. AI startups are once again forced into the multi-million-dollar meat grinder of federal court.
And here's the brutal irony. Squires forces them into federal court, knowing full well the judges there are bound by recentive and are going to slaughter those patents.
It is the defining tension of the two-track public domain.
He's handing out paper armor, forbidding anyone from testing it internally and pushing them onto a battlefield where judges have flamethrowers.
Yeah, the PTO is aggressively generating assets, and the courts are ruthlessly destroying them.
But wait, if the PTO is throwing the doors open and you can't kill patents internally, why aren't we seeing a massive flood of millions of new applications clogging the system?
That is a brilliant question. And it brings us to the hidden financial engine of the Patent Office. The newsletter calls it the myth of patent growth.
Because if you just look at government data, it looked like a golden age of invention.
It does. Total published utility applications doubled from 200,000 in 2002 to about 425,000 in 2024.
Looks like exponential growth.
But the newsletter includes this highly revealing chart from Patent.io, run by Professor Dennis Crouch. It completely destroys that narrative.
Yeah, that chart is essential.
It divides that massive mountain of applications into categories. The most important is U.S. origin original applications.
Meaning genuinely brand new ideas from American inventors hitting the office for the first time, not continuations.
Right. On the chart, it's a blue band at the bottom. And that blue band is completely depressingly flat.
Completely flat for 2 decades.
Raw numbers haven't grown since 2002. As a percentage, it plummeted from 33% of all filings down to an astonishing 13% recently.
Okay, the math demands an explanation. Where did the extra 225,000 applications come from?
2 sources. First, a massive influx of foreign origin filings from Asia and Europe.
Makes sense with globalization. And the second,
The aggressive exploitation of domestic continuations.
I really want to explore continuations because this is a super controversial corporate strategy. How do companies weaponize paperwork?
Okay, hypothetical. A major tech company files an application in 2015 for cloud data storage. It's a massive document. Under U.S. law, you can keep that original family alive for years by filing continuing applications.
Meaning you just submit the exact same text again.
The same text, the same diagrams, but you rewrite the specific claims at the very end, which define the legal boundaries of what you own.
You're updating your property fence line without buying new land.
Exactly. Flash forward to 2024. A scrappy startup releases a novel cloud feature. The big tech company sees this, looks at their pending 2015 continuation, and specifically drafts new claims that perfectly describe the startup's 2024 product.
That is devious.
Because the claims link back to 2015, they argue, we actually invented this 9 years ago. They get the patent and immediately sue the startup.
They just keep an application dormant to dynamically target competitors later.
It's incredibly common. Companies build dense patent thickets this way. Continuations tripled since 2010.
So we weren't inventing twice as much. Corporations were just filling out the same paperwork twice as often to harass competitors.
Precisely. And the previous U.S. PTO administration under Director Vidal recognized they were choking on recycled paperwork, so they set a trap right before leaving.
The new fee rules.
Right, effective January 19th, 2025. They put an exorbitant cover charge on the copier machine.
What were the penalties?
Massive surcharges for late-stage continuations. Filing one 6 or more years after the earliest benefit date gets a $2,700 surcharge. 9 or more years out, the surcharge skyrockets to $4,000.
That's not just administrative overhead. That is a targeted financial penalty.
Highly intentional behavioral economics. They also hike fees for PAL, requests for continued examination, and doubled excess claim fees.
Did it work? Did hitting them in the wallet suppress the zombie patents?
The data suggests yes. The 2026 projection on Crouch's chart shows U.S. original applications rebounding from 13% back to around 18%.
Because the recycled paperwork became too expensive.
Exactly. The total volume is physically shrinking.
Okay, let's pull all these chaotic threads together. Original inventions are flat. Late-stage continuations are being taxed out of existence. Squires is pushing examiners to approve AI under the Kim memo, but refusing PTA reviews. And federal judges are waiting with guillotines under recentive.
It is a totally fractured landscape.
How does anyone survive this? How do you play 2 contradictory games at the exact same time?
This is where Section 5 of the CLG newsletter comes in. The playbook. Jack Russo and his team lay out a highly pragmatic strategy.
Let's walk through it. What is the filing strategy?
Recognize the immediate opportunity. The internal U.S. PTO environment is the most favorable since the Iancu era.
So file aggressively now.
Yes. Capitalize on the Kim memo's lowered standard while it exists. Get the assets while the getting is good.
And this is the biggest caveat, you can't just draft it to please the examiner. The examiner isn't the final boss.
Right, the drafting strategy dichotomy. You must draft the technical language specifically for the recentive federal courtroom, not the Desjardins examiner.
How do you draft for a hostile court? Let's say I built an AI that optimizes shipping routes.
If you just claim a method for applying generic machine learning to analyze shipping routes, Squire's US PTO might approve it.
But the second I sue a competitor,
The federal judge will say analyzing routes is abstract math and instantly invalidate it.
so how do you build a bridge over that cliff?
You have to claim concrete structural realities. Detail the specific neural network architecture, the unique training methodology, the novel data structures.
You have to prove the tool itself is structurally new, not just that the outcome is profitable.
Exactly. Explain exactly how the model physically improves memory usage or processing speed. Armor the patent with hardcore engineering specifics to survive cross-examination.
Makes perfect sense. Now, what about the continuation strategy? How do you manage existing portfolios without going bankrupt on those new fees?
The playbook mandates an immediate audit. Look at your pending applications approaching that 6-year or 9-year threshold.
Before the $4,000 penalty triggers.
Right. Accelerate necessary filings before those dates. But also, use regulatory arbitrage. Consolidate multiple fragmented claim sets into single massive applications.
Even though you pay excess claim fees.
Yeah, because sometimes paying excess claim fees on one application is substantially cheaper than paying 5 separate $4,000 late-stage surcharges. Play the bureaucratic math.
I love that. But the playbook also comes with a flashing red warning light regarding those SMEDs, the subject matter eligibility declarations.
A critical caveat. Remember, if an examiner hesitates, you can file a sworn expert declaration saying, this improves the computer to get the patent issued.
The get-out-of-rejection-free card.
The newsletter warns, use these very selectively. Every sworn statement you submit becomes a permanent public record in the prosecution history.
Oh, shit, a trap.
Yeah. 3 years later, when you sue an infringer in federal court, their defense counsel will pull that SMED and weaponize it using estoppel.
Prosecution history estoppel. Let's explain that. It's like telling your auto insurance you only drive once a month to get a discount, but then trying to file a claim after a rush hour wreck.
Right. The insurance company says you're legally bound by your previous statement.
You are stuck with the narrow reality you created.
Exactly. If you file a SMED relying on a highly specific, narrow definition to convince the examiner, you are permanently bound by it. You can't suddenly argue your patent covers a competitor's completely different product.
And if your trial expert contradicts what you swore to 3 years prior,
it creates a massive impeachment risk. You hand opposing counsel the ammunition to destroy your credibility.
so you take the easy administrative path today, but lay landmines in your future litigation path.
Precisely. Which leads to Russo's honest caveats. Practitioners have to keep reality in check.
What's the biggest reality check?
Squires has not repealed the Alice precedent. Legally, he can't. He's not the Supreme Court.
The ENCO systems case proved the courts don't have to follow his internal memos.
Right. He just made the USPTO a friendlier forum. And look at the raw volume of patent grants. It's actually totally flat.
Wait, if reversal rates spiked and examiners are lenient, why aren't total allowances skyrocketing?
The data from Parola Analytics shows granted utility patents in 2024 were roughly 325,800. In 2025, almost exactly the same.
That feels contradictory.
The shift is entirely contained within the eligibility treatment, specifically for AI and software. It's not a blanket increase for all patents. Plus, the massive drop in continuations actively offsets the new AI allowances.
The pie isn't getting bigger, the slices are just changing flavors.
Exactly. And Russo emphasizes metric discipline. Writers constantly conflate the examiner's first action rejection rate with the PTVS affirmance rate and the Federal Circuit invalidation rate.
They are three distinct scoreboards.
Yes. A high allowance rate at the USPTO does not mathematically equate to a high survival rate in Federal Circuit Court.
And finally, the wild cards. The things that could blow up this entire two-track paradigm overnight.
There are three massive wildcards. First, direct legislative action. The Patent Eligibility Restoration Act, or PERA. If Congress passes it, it rewrites Section 101 completely.
Ending the divergence by congressional force.
Right. Second wildcard, the court striking back. If a frustrated company sues over Squires centralizing the PTT, the Federal Circuit could issue a writ of mandamus.
legally forcing him to reopen the PT Bates.
Exactly, bringing back the cheap validity checks.
Yeah.
And the third wild card is just the political calendar.
A change in presidential administration or leadership in 2029.
Right. A director's memo can be easily undone by the very next director's memo. The foundation is temporary.
So until a wild card drops, we live in this deeply divided reality. You have to be aggressive enough to capture the territory the U.S. PTO offers, but defensive enough in your engineering to survive the federal courts.
It's an incredibly dangerous tightrope walk.
Which brings me back to that core philosophical tension. If the agency issuing patents and the courts enforcing them can't agree on what an invention actually is in the AI age, what does that mean for the concept of owning an idea?
It's the ultimate question.
Does this bizarre system benefit the massive tech giants with unlimited capital for multi-year litigation? Or does it actually serve scrappy founders who can now easily build a patent portfolio to attract venture capital, even if the patents are structurally fragile? It's a high-stakes tension, and it's absolutely going to define who controls the next decade of American innovation.
Led by Jack Russo, Computer Law Group LLP is a bespoke business litigation and founder-friendly boutique law firm with offices and licensed attorneys in Silicon Valley, New York, and Tampa Bay. And you can reach Jack at computerlaw.com and his team at www.computerlaw.com, where the newsletter we refer to is published in detail and readily available, commitment-free with no paywalls or other charges.
Tune in next time on The Valley Current.